gone for change of language or gone or. Insights on India. COM25. Version of mode of transmission from standard definition SD to high definition HD or vice versa. A company LLP can use news gathering equipment other than DSNG, such as optic fiber, backpack, mobile, etc. Ease of doing business. Specific timelines for grant for permission. Limited liability partnership LLP entities can also seek permission. A news agency can get permission for a 5-year period, 1 year at present. A channel can be uplinked by using facilities of more than one teleport satellite at present. Simplification and rationalization. One composite set of guidelines. Structure of the guidelines has been systematized. Penalty clause. Separate nature of penalties have been proposed for different types of contraventions. Uniform penalty at present. Insta links. Content regulation on TV, other platforms. Mains links, Q. Has digital illiteracy, particularly in rural areas, coupled with lack of information and communication technology (ICT) accessibility, hindered socio-economic development. Examine with justification. UPSC 2021. Isn't reservation for the poor a good thing? Direction. The article discusses what repercussions the EWS judgment can have on the reservation policy with some suggestions to reform the reservation policy. This is a very good analysis of both sides of the issue. Context. The SC has upheld the constitutionality of the 103rd Constitution Amendment, which provides 10% reservation to the EWS but excludes the poorest of poor among the SCS, STS and OBCS from this quota, igniting debate over the issue of reservation. Debate on the issue in the context of the recent SC verdict. Should the reservation be a means to address poverty? No. Reservations result in quotas, setting aside the principle of equality. Thus, reservations should be kept for the most challenging types of discrimination, rather than temporary issues like those arising from economic reasons. Yes. Reservation is not an exception to the rule of equality but is required by the principle of substantive equality. It is open to a democratically elected government to introduce reservation on grounds other than caste as well. Is it necessary to reconsider caste-based reservations? The SC in the 1992 Indira Sawhney verdict justified the positive discrimination policies caste-based in existence in India since independence. However, 30 years after the Mandal decision, caste is not to blame for the kinds of socio-economic inequities that exist today. Can the reservation be provided without proof of inadequate representation? Reservations for SCS, STS and OBCS were introduced with proof that these communities were not adequately represented. But, the EWS quota has not been brought under Article 16(4) of the Constitution, which requires proof of the inadequacy of representation in government services. Also, reservation is no longer a special tool meant to address discrimination and can be used to address all forms of backwardness and disadvantage. How does the EWS affect the Equality Code of the Constitution? As the Constitution authorized the state to make any positive discriminatory provision, it does not violate the Equality Code. This is a consequentialist movement in Indian social justice discourse because it is changing the nature of reservations in the country. Way ahead, a comprehensive debate on reservation policies involving all stakeholders is needed. Certain reforms like subclassification of beneficiaries are necessary to enhance equal access to quotas which have been cornered by certain castes for generations. If a class can be used to determine beneficiaries, why not religion? In light of substantial evidence of religious discrimination, prejudice, and disadvantage against minorities such as Muslims, this issue requires an immediate response. 26 or Insights on India. Com. Insta-links. The EWS Judgment in the Shadow of Pandora. Mains links. Q. The economically weaker sections EWS judgment fails to uphold the constitutional values meant to end the perpetuation of discrimination against the SCS, STS and other backward classes. Critically examine. 250 words. New draft Digital Data Protection Bill tabled for comments. Direction. The article highlights the key provisions of the new draft and where it falls short in protecting citizens' rights. Context. The draft Digital Personal Data Protection Bill, 2022, was recently opened by the Union Ministry of Electronics and MeitY for public comments. About the new draft, the bill seeks to establish a comprehensive legal framework governing digital personal data protection in India, recognizing both the rights of citizens, digital Nagrik societal rights to protect their personal data, a strict user consent regime for data processing. Duties, obligations of the data fiduciary, consumer internet and social media companies to process and use collected data lawfully. Background. The revamped draft was released after the government withdrew an earlier version, the Personal Data Protection Bill, 2019, that sparked outrage from big tech and civil society. The 2019 bill was prepared by former Supreme Court Judge B.N. Srikrishna to guarantee the protection of persons' personal data and to establish a data protection authority. The government has decided to come up with a fresh bill that fits into the comprehensive suggestions made by the Joint Committee of Parliament (JCP) on the 2019 bill. The JPC had submitted many recommendations such as broad data protection in line with Case Puttaswamy judgment of 2017 to the 2019 bill in 2021. Key provisions of the Digital Personal Data Protection Bill, 2022. Data Protection Board, it will act as the adjudicating body to enforce the provisions of the bill. Data protection of FISA and Independent Data Audit. TOR. They will be appointed by businesses of significant size based on the volume of data they process to evaluate compliance with provisions of the law. Easing cross-border data flows. The new bill relaxes data localization rules and permits data to flow to certain global destinations, based on their data security landscape. The previous bill mandated enterprises to keep a copy of sensitive personal data within India and prohibited the transfer of critical personal data from the country, the most important concern expressed by its firms. Right to correction eraser. Users will have the right to have their personal data in the custody of enterprises corrected and erased. Duties of companies. Companies will not be obligated to keep user data that no longer serves a business purpose. Companies should not process personal data that could harm minors less than 18 years of age. Promoting startup ecosystem. The government may also exclude certain enterprises from bill's restrictions based on the volume of users and personal data handling. Exemptions. The central government has been empowered to exempt its agencies from adhering to provisions of the bill in the interest of sovereignty and integrity of India, security of the state, friendly relations with foreign states, maintenance of public order, or preventing incitement to any cognizable offense. Penalties. Focuses more on financial penalties than a criminal conviction. For companies, between Rs 50 to 500 crore for data breaches and non-compliance. For users, a consumer who submits false documents for an online service or makes bogus grievance complaints may face a 10,000 rupees fine. Significance. Based on global best practices, the government says that it has reviewed the personal data protection laws of Singapore, Australia, the European Union, and the US. Economic benefits. The bill draft also considers the country's $1 trillion digital economy goals and the rapidly growing innovation and startup ecosystem. Insights on India. COM27. TEM. Concerns. State agencies are granted broad vague exemptions. This may not meet the necessity and proportionality tests outlined in the landmark Right to Privacy Judgment Case Puttaswamy case of 2017. The independence of a proposed regulator, the Data Protection Board, has been reduced. Unlike the Data Protection Authority, which is envisioned as a statutory body under the 2019 bill, the appointment of the chairperson and members of the board is entirely up to the discretion of the central government. Relaxing data localization requirements will make it difficult to detect and investigate non-compliance and breaches. Conclusion. Though the bill is significantly simpler this time excluding non-personal data, it will require several modifications before it is practical. Install links. Data Protection Bill. Mains links, Q. Critically analyze the provisions of the Data Protection Bill. Mention the changes suggested by various committees on the Data Protection Bill. The need to have full disclosure electoral bonds and political funding. Direction. This article demonstrates how electoral bonds have concealed funding to political parties even more, its impacts, way ahead, and a best practice in the conclusion. Context. According to an RTI reply, electoral bonds worth 10,246 crore rupees have been sold by the State Bank of India (SBI) since the instrument was launched in March 2018. Background in which electoral bonds were introduced, political parties violating FCRI. In 2014, the Delhi HC found the leading political parties guilty of illegally accepting donations from a foreign company, in contravention of the Foreign Contribution Regulation Act FCRA 1976. Amending FCRI. Following this, the two parties came together to amend the FCRI to retrospectively legalize the violations, bringing in full anonymity to corporate and foreign political donors. Old vs new provisions. Previously, only profit-making domestic companies could contribute to political parties. Now, loss-making can as well. Foreign companies could not previously contribute. A foreign firm operating in India or a foreign entity through a shell company may fund Indian political parties now. Capping cash donations. In 2017, the anonymous cash donations to political parties were reduced from 20,000 rupees to 2,000 rupees to ensure greater transparency in political funding. Introduction of electoral bonds. The Electoral Bond Scheme (EBS) announced in the 2017 Union Budget was notified by the central government in 2018. These bonds can be purchased from select SBI branches by any Indian person or corporation incorporated in India under the scheme. The introduction of electoral bonds brought a new form of anonymity to thousands of crores of donations. 28. Insights on India. Com. How did electoral bonds introduce a new type of anonymity? By reducing public and legislative oversight. For example, only the ruling party via the SBI has a full account of all donations being made via electoral bonds. Political parties do not disclose electoral bond donors. The only requirement is the annual audit reports with all donations received via electoral bonds. However, these reports are submitted with great delays. Impact of anonymity dilutes one voter, one vote principle. This is because electoral bonds give political power to companies, wealthy individual donors, and foreign entities to influence public policies. Undue advantage to the ruling party, whether at the center or in a state. Suggestions given by the SC. In 2021, in response to ADRPIL challenging EBS as unconstitutional, the SC refused to stay the sale of electoral bonds and suggested matching the following between the purchaser of the bond and political party to bring in transparency. Problems with the match the following approach. No ordinary person has the time or money to go through documents on government websites or go through income tax returns. The total number of registered companies is unknown, and many do not report political donations even if they file annual financial statements. All private companies' annual reports are not easily accessible on the government's website since they are not mandated to produce them aside from filing annual returns. Way ahead, the information regarding donors and donations should be accessible to the Parliament, the Election Commission of India, and the opposition via SBI. The RTI must be strengthened, as only RTI petitions filed with the SBI provide insight into the millions of dollars spent on political parties. Conclusion. Companies and political parties can show moral leadership by voluntarily disclosing the identities of recipients and donors, as the Jharkhand Mukti Morcha did recently. Insta-links. Opaque political financing could cost democracy dear. Mains links. Q. Trace the changes witnessed in political funding with the introduction of the electoral bond scheme. Critically analyze the potential of electoral bonds in fulfilling the goal of transparency in political fundraising. 250 words. 8 of a law to prevent cruelty to animals. Need and concerns. Direction. The article discusses how the shortcomings of the Prevention of Cruelty to Animals Act of 1960 led to the creation of a new draft on the subject, key provisions in the draft and future challenges. Context. The Union Ministry of Fisheries, Animal Husbandry and Dairying have opened a draft Prevention of Cruelty to Animals Amendment Bill, 2022, for public comment. Background. The draft is an attempt to overhaul the Prevention of Cruelty to Animals (PCA) Act, 1960, introducing 61 amendments to the law. along with animal welfare organizations. The Supreme Court in A. Nagaraja case 2014 asked the Parliament to amend the PCA Act to provide an effective deterrent. In 2020, a group of MPs cutting across party lines wrote to the then Animal Husbandry Minister, urging that the punishment in the 1960 Act be increased. The main changes proposed in the 1960 law: 5 freedoms to animals. Every person in charge of an animal must ensure that the animal has freedom from thirst, hunger, and malnutrition. Discomfort due to environment, pain, injury, and diseases, fear and distress, and the freedom to express normal behavior for the species, defining gruesome cruelty, any act involving animals that causes extreme pain and suffering and is likely to leave the animal disabled for life. It proposed to include bestiality as a crime under gruesome cruelty. Several offenses have been made cognizable. This means offenders can be arrested without an arrest warrant. Responsibility of local governments. In the case of a community animal, the local government municipality panchayats shall be responsible for taking care of such animals in a manner developed by the state government or by the board. Or Insights on India. Com 29. More stringent punishments. The draft proposes fines from Rs 50,000 to 75,000 or the cost of the animal, whichever is more, or with imprisonment of 1 to 3 years, or with both, for the offense of gruesome cruelty. It suggests a maximum of 5 years imprisonment for killing an animal. Need for strengthening the law, increasing instances of cruelty to animals in India. Poor deterrence for potential offenders. First-time offenders under the PCA Act are punished with a fine of Rs 10 to 50, otherwise a fine between Rs 25 to 100, a jail term of 3 months, or both. Concerns. Simply increasing the quantum of punishment may not be enough to stop cruelty against animals. Some already marginalized communities like Madras and snake charmers may be disproportionately affected. SC on cruelty to the animal. While recently hearing the Jallikattu case, prevention of cruelty is not an absolute idea. The Constitution commands us to be compassionate to all living creatures, but it should have a balance. Should we, for example, be compassionate if a mosquito lands on us? Animals should be treated as friends and brothers, and they have the same rights as human beings. The Constitution recognizes liberty, which is inherent in every living being, whether it be in any form of life. Way ahead. Behavioral changes through sensitization programs. Steps are needed to mitigate the larger issues of vanishing animal habitats and climate change exacerbating man-animal conflict. Insta links. Prevention of Cruelty to Animals Act, 1960. Mains links, Q. Critically comment on the center's move to notify new rules to regulate livestock markets under the Prevention of Cruelty to Animals Act, 1960 PCA. 200 words. New draft Digital Data Protection Bill. How it compares with the older version and laws elsewhere. Direction. Previously we have seen the key provisions of the